No. Oh, se lo comí sì. हमें रखा था यार अट्ठाईस तारीख का है यहाँ में रखा था नहीं रखा है ये रखे हैं खाली था मैं वो उठा के ले गया वो जो रखे हैं वही उठा के ले गया क्या है डाल दो नहीं लेना एक वन रखा है ये उल्टा पुल्टा करता अच्छा ठीक नहीं है हाँ
For judgment, item number 16.
The writ petition is dismissed. Yes.
I'd like to mention item number 3, so to check in. Because I have some additional difficulties, so if this matter can be set after 1 week.
Right.
And Lordship,
What is the
this
matter about?
matter-
Matter is about what? That is
the
item number 3.
petitioners are seeking reinstatement and
Mr.
relaxation.
Jamil, this is item number 3. Let me just take 1 and 2.
Lordship. Lordship, I'd like to mention item 51
Let us finish it. I won't sit for long. Don't worry. Let's see.
Item number 1.
Lordship, he has just informed me that he's not getting the link.
He's not getting the link.
Yes, not getting the link. Yes.
Where is the
Advocate
item?
General, Lordship.
Ah.
I can, 17. 17.
He's not getting the link.
Yes.
Get the IT people out there. Just wait for some time. Let me complete the others.
Item number 1.
Yes, what is this?
Please, here an affidavit in the file, Lordship, to the affidavit filed by the state, Lordship.
We are filing it.
Lordship, I'll be filing, if I may be given a week's time, Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the affidavit in reply to the affidavit filed by the respondent is in the process of being prepared and be filed within a week. List the matter on 11th of March. The affidavit be filed by 8th of March.
For admission, item number 2.
That is, Lordship. Lordship, kindly grant me 2 weeks time to file affidavit in reply to the affidavit in petition filed by private respondent. 4.
The request of Mr. So-and-so, the learned counsel for the petitioner, matter stands adjourned to be listed after 4 weeks. In the meantime, the
I'm for the respondent.
petitioner shall file their affidavit in reply.
Obliged, Lordship.
Yes, 3 to so and so. Let us pick.
May it please your Lordship. The Lordship, this is the case filed by the part-time instructors whose job has been terminated, Lordship. My Lord, they are appointed under the scheme related to SSA, Samagra Shiksha Lordship. Earlier, when the proceeding was pending before the Honorable Court, a categorical submission was made by the state government, as well as a document was submitted before the Honorable Court to show that the scheme related to the part-time engagement of the part-time instructors been stopped altogether. Now, Lordship, after the matter was disposed with a direction to pay their salaries for the job that they have already rendered, the services they have rendered. Later on, through RTI, they came to learn that the scheme is still continuing, and part of the project to be approved by the project approval board. There, it was specifically shown that the salary component for the part-time instructors is also still continuing. So we have come back the second time.
So
Lordship.
you say that the
Lordship.
termination which was made of those petitioners herein was done illegally because there was no basis taking into account that the project is still continuing.
Yes, Lordship, they have misled this Honorable Court.
So who is the
Yes.
best person to say whether the project is continuing or not?
By the document, Lordship,
No, who is the best person to say? The union.
the union, Lordship, the union.
Yes, Mr. Yangawati, now your turn comes. You want to
Sir,
file
I'm
an
asking for
affidavit.
I'm asking for some time, Lordship, that's why.
You are going to
But in
file
any
it.
case, Lordship, there is no difference between teacher, part-time teachers, I think the component, the salary is one goal, Lordship. There is no difference. For the salary, there is only one package only. No differences.
But don't you?
No
pay-
backup, Lordship.
Don't you pay the salary on the basis of this RTE Act, Right to Education Act 2009?
Lordship, as a whole sum for the teachers. For building, that is different. For infrastructure, that is different. But
So the-
for teachers, there is no breakup, Lordship. For teachers, there is no breakup. We give it in whole sum.
So the project,
Be it teacher, be it the part-time teachers or the full-time teachers. It is given in one.
okay, you filed your affidavit,
I'll be filing my, that is why
You will be filing.
I'll be filing this.
when?
2 weeks time, Lordship. Lordship, 3 weeks time, in fact, because I have to get the signature from the.
Let us have it on then on 1st of April.
Lordship, I don't know what affidavit my learned friend is going to file. Because the matter was pending and it was heard. And then.
But it was heard by
it was said
another
Bhatt
judge.
heard, and then thereafter it was released from Bhatt heard. Now, so far as the present writ petition is concerned, I'm sure the present writ petition is not maintainable at all. This is the second round of litigation. In the earlier writ petition, they have challenged an order issued by the NIMS, Nagaland Education Mission Society. The petitioners are part-time instructors who are appointed in a flagship
Now,
routine.
is there a stay working?
No, they are not working.
No, is there a stay?
No
There is
stay, no
there is
stay.
So
Yes.
under such circumstances, if there is a delay on the part of the delay would be of the petitioner.
Yes, but Lordship, one aspect, they are appointed for a period of 6 months only. And then it was extended from time to time. The last extension was expired in 2018. After they were terminated from service, discontinued rather.
And
They
how many years did they prior to 2006?
About 3-4 years they have worked.
3 years.
And thereafter,
So
Lordship,
they
what
don't come
happened?
within the ambit of new resolution adopted yesterday by the Nagaland Legislative Assembly.
They are not included there. They are not included, unfortunately. So what happened, Lordship?
No, wait, Mr. Jamil, I understand. But you see, if it was on a Monday or yesterday, last Friday, I would have 100% finished off the matter. But the fact that I'm leaving today, so makes it further continuing out here would not make any sense. So when the union, who the person who is funding, they are the funding people, let them put it on way of affidavit, then the matter would be clear. Like
They have already filed an affidavit, additional affidavit they have filed. And then they have explained.
You want to file it or not? Do you want to file an affidavit or not?
They did file
No,
an
no, if you
affidavit,
don't,
Lordship.
we
Yes.
will do one thing. You don't want to file an affidavit, we'll fix it on 11th of March. Let's fix this matters on 11th of March.
It is not a comprehensive affidavit, but I cannot direct them to
No,
file
it's
a.
okay, but
Yes,
otherwise,
Lordship.
let's have it on 11th of March. Fix the
Lordship.
matters on 11th of March, on which date, Mr. Younger, the pleadings having been complete, list the matter on 11th of March, on which date an attempt shall be made to dispose of the petition.
Madam,
For orders, item number 17.
Lordship, Lordship.
Yes, Mr. Advocate General.
Please, I'm sorry that I was not available yesterday.
No, it's okay. No,
This-
Mr. Advocate General, I fail to understand a way a particular aspect to the matter. There is a case where the rules have been notified.
Correct.
If the rules are notified, then automatically it comes into play
That's right.
unless the state government repeals it. There's no
Right. Correct. Now, actually, the point involved is very simple.
Yes.
And we have also tendered our opinion on these lines. Maybe all that is required is my personal meeting with the cabinet, which is going to be arranged. I can assure this court, give me some time, I will work it out. There are some, in fact, I was involved in this meeting in 2006
I see.
when Justice Sudarshan Reddy was the Chief Justice.
Ah.
And in that meeting, Justice Gogoi, as he was then Justice Amitabh Roy, all these people were there, along with our Honorable Chief Minister, myself, and the Chief Secretary. When we said that we agree for this type of separation, and they gave certain parameters. So that is how this change started. But sometimes what happens in Nagaland is when they go into some of these issues, some people have a little bit of understanding in a different way. Now, to iron out all these things, it is not the intention of the legislature or cabinet to be at cross points with the law. But I think if I participate in a cabinet meeting which will be specifically held for this purpose, I think we will be able to iron it out. Whatever clarifications further is required, there's no qualms as far as the applicability is concerned. But sir, since we have waited so long, it would be more appropriate that we can sort it out in a gentle manner so that we will have no problem at all. I can assure you of that. You can even record my statement. I have no problem.
I duly record that. But only thing which I am there, because on the first day when I set out here, I got
Yes.
of a matter. That's a petition filed by one lady,
Yes.
wherein
New
husband,
News Chadi.
the husband was working out there, and then
Yeah.
after the working completion, and as per the Nagaland, these rules, he
Yeah.
retired at the age of 60. Now, taking into account that applying the Nagaland recruitment rules of 2009,
Retired.
now they have made her now the question of recovery, non-payment of pension, all these things are happening. So,
Right.
I think, Advocate General, these needs to be, because one also has to look into those
Right.
concerned when more particularly the question of pension is inserted. But the pension has not been released only because of the fact of the applicability of the rules, whereas on the face of it, the rules are applicable in law. We can't say that the rules are not applicable. The only way out for the for a cabinet to say is that okay, we now we have another rule, so we repeal these rules. So that is the only thing the cabinet can do. So otherwise, okay, for this matter, for this contempt matter, it is okay. This can
Correct.
go for some time. But what do you say about taking care of a person whose pension is now being stopped? Not only the pension is being stopped, now question of recovery is being sought on account of there is a long, because another 4 years he has worked. Because otherwise 35 years was the other ways as per your Nagaland Recruitment Act of
Correct.
2009. But as per this,
Correct.
60 years, and he was allowed to work all this while. Now she's not getting the pension after the death of the husband. I think
I will look into that matter. I will look in. Actually, this law also, when this was enacted, it was challenged before Honorable Justice Gogoi at that time. It was upheld by the High Court, and I appeared also before the Chief Justice of India. They upheld this law at that time because of serious unemployment problems among the youth in Nagaland. Well, at that time, if the youth don't get government service, they used to enter into other negative fields. But as far as this particular case is concerned, I will ask for the file. I will personally look at it.
Yes,
That's
I'll ask the person who is assisting you. I'll give her a number. So something needs to be done out there because the question of recovery is being sought. The
No,
question
I will.
of
I will stop it straight
the
away.
matter urgent in nature.
A human element also has to be looked into.
Yes.
More than law.
In fact, that is why I sought your presence
Yeah,
today.
it is
The
my
fact
pleasure
that-
to assist. I will look into it personally.
Yes.
Because law, if it does not have human element, then it is no law.
At when should I fix it matter?
In fact, I am there on 13th and 14th. 12th, I'm in Gauhati.
Okay.
4th and 5th also.
You'll be appearing in that full bench? No.
No, I think I will be appearing in the airport matter on 15th, 14th. 13th, I'm appearing in some other matter.
Okay.
And on 12th, I'm appearing in Gauhati. 4th and 5th also, I'm in Gauhati.
Yes.
So when can I fix this matter out here? Because this,
I think it can be fixed on 14th. Meanwhile, I'll call for the file. I'll look into it.
I'll have it on 14th.
Yes, please.
This matter along with the other writ petition.
Please.
Both the matter.
I will look into it. I'll look into it as soon as I'm there. I will address the issue.
Just one submission, Lordship. Not only the pensioner, but in Gauhati Street, plus I have got information that they are not no more giving salary after reaching 35 years.
Madam, kindly see. I can only take into account matters which are before me.
Lordship.
Not for matters outside.
Lordship.
Yes, this is a matter which came up before me on the last Monday when
Exactly,
I took up the matter. So I remember that matter. And that is why
Yes,
yesterday
yes.
when I was taking up this matter, it reminded me because of that. You moved that matter.
Exactly.
Yes. Okay. By an ordinary day, the matter, the instant contempt application has been filed alleging willful and deliberate violation of the judgment dated 25/8/2020 passed by this court in WPC number 192/2018. From a perusal of the said order, as well as the issue which arises is regarding the implementation of the Nagaland District Court Employees Service Rules 2017. It is relevant to take note of that initially the said rules was notified by the notification dated 8/9/2017 stating inter alia that the said rules shall come into force on the date of publication in the official gazette. On the very date, the said notification rules were published in the official gazette. Thereupon, by the notification dated 3/9/2018, the notification which was issued on 8/9/2017 was recalled. This notification dated 3/10/2018 was put to challenge before this court. In WPC number 192/2018, during the pendency of the said writ petition, the government of Nagaland came up with another notification on 19/6/2020, whereby the notification dated 3/10/2018 was recalled. Resultantly, the notification dated 8/9/2017 again came into force. It is under such circumstances the order was passed by the coordinate bench of this court on 25/8/2020. Be that as it may, this court had been taken into consideration, be that as it may, this court had taken into consideration that once the rules have been notified, the rules by law comes into play. Under such circumstances, this court, while hearing the matter, sought the presence of the learned Advocate General of the Government of Nagaland, and accordingly, the matter was fixed today. The learned Advocate General, appearing through video link, submitted that there is no quarrel with the proposition regarding the rules had already come into play. But however, there is requirement of creasing out certain areas, and for which he would be meeting the cabinet as well as the Chief Minister of Nagaland in 2 weeks' time, sometime in the second week of March. And as such, he requested the matter be listed again on, what is the date, Mr.?
On 14th, will it be all right?
On 14th of March 2024. Taking into account the submissions made by the learned Advocate General, Government of Nagaland, this court fixes the matter on 14th of March 2024. This court also have taken note of that there is a writ petition being WPC number 21/24, which is fixed on 11/3/2024. The issue therein is in relation to the implementation of the Nagaland District Court Employees Service Rules 2017. Under such circumstances, this court fixes the said writ and tags the instant contempt proceedings along with the said writ petition, that is WPC number 21/2024, and the matter, the said writ petition, be listed along with the instant contempt proceedings.
Obliged.
Yes,
I'm obliged.
yes. I hope you are able to impress your government.
No, we will, in fact, I was to be in the hospital at 10:30.
I see.
There was a small surgery for somebody in the family. The hospital is nearby. But when I came to know that you are leaving at 12:30, I came back only to assist the court. I'll take care of it.
Thank you.
Welcome. Yes, please.
Item number 14.
Go.
Yes, you wanted,
Worship,
what do you want?
let it come after 2 weeks.
After we come up after 2 weeks. This is the matter at the request of Mr. Moa Imchen, the learned senior government advocate. Matter stands this. What is the posthumous regularization of the year for it? why such a delay? You have not filed your affidavit from 2023. Who has not filed? Reply not. You have not filed. They have filed their affidavit. Then, what do they say in the affidavit?
The state respondent is like.
Did you complete the 30 years prior to your death?
No, you.
Matter is covered.
I retired after 7 years.
So how can you get? You have completed 29 years and you did not have 30 years of service, 73, 2015, how will it come in? Anyways, he's helping you out. At the request of Mr. Mohan Chin, the senior government advocate, Matters Tension to be listed when?
Public. After.
For admission, item number 15.
Yes, your matter, I suppose.
Lordship. I communicated government expressed their lordship whether respondent for can include the lordship my structure is negative. So lordship because I faced some preliminary objection. I faced objection with regard to maintainability of
On the ground,
suppression of material facts. Suppression of material facts.
then,
Approaching the court with a black hand.
Yeah.
And questionnaire parties also.
yes.
Because lordship knows the village council is a.
But Mr. Counsel, can you tell me one thing?
Before coming to the.
Suppression of material facts, okay. But whether it is suppression of facts or suppression of material facts, the issue involved is in a country where we have law, can you excommunicate the person for all times to come? So there, I didn't want to pass a judgment because what will happen? It will have a clear effect. Or tomorrow, nobody can do it. It will become against. They have. It will also show the petitioner in a much upper hand against the village authorities. That is why I requested you to have a talk with your client. Because if any order is passed, it will further. These are all ego cases. The ego case is why he got a police. That's it. Now the question is, the moment I pass a judgment, he will take you this judgment, take the police and go to you and show it in your face. Then it would more be, you may take a decision to the effect that look here, a lot of time have gone, we have thought about it. Take a decision. I think you need to advise your client to that. Because it will show, it will be more, what do you call, the person concerned would be the village authority who had the authority to be, it will be more undermine their prestige. What do you say?
Yes, that is the reason why lordship I formulated lordship opinion. Right? Ask them. However, lordship.
Because if I
knows the village council.
understood,
The standard of the village council lordship.
whatever order has been passed, they're to locking it for life. It's too much, isn't it?
Yes, lordship. That too without any basis, lordship.
Eh?
That too without any basis. They don't have the legal sanction. And that your lordship, sometime we can, I'll try to.
I file amicable solution. Let me put it on the order that they will try for an amicable solution. And we'll have it next week or 2 weeks after that. Yeah, you say amicable solution means you will have to talk with them. Have a talk with them and advise your client. Because if I do so, this way, he will not at all give any regard to you. And I understand that in all other villages, they have some authority. And the moment I pass an order to this effect, it will have a serious repercussions upon, because their authority would be absolutely undermined. I still understand that the question of excommunication, which is a concept which is there, this is prehistoric, which is going on, but it is being still followed in certain parts of the country. I think if I pass an order to the effect that you cannot, it ends there. Because the customer, you are saying on the customary law, but that is not codified. Then, okay, upon hearing the learned counsels for a party, this court is a further opinion that and further chance be given to both the parties to amicably resolve the disputes amongst them. Under such circumstances, this fifth court fixes the matter again on 18th of March, on which date both the parties shall apprise as to whether there has been any amicable solution. I think this will give you a handle.
What want you to